of Stratasolve, stratasolve.com.au. Alongside me on a different side today, physically speaking today, we like to do that to keep everybody on their toes. Frank Higginson, partner, Hines Legal, and industry expert of some renown. Frank, welcome.
Hello, Chris. Hello, everyone.
You'll notice that Frank has a slightly different physical aspect. He's trying the whole sort of standing up webinar approach. I am still seated. Again, we're just trying new things, mixing it up. For anybody new to the show, just to clarify, live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. That won't be an issue as of next week, or whenever you're watching this. So to follow us on Facebook, go to the Hines Legal page and hit the like button and icon. And if it's on YouTube, you hit the subscribe button and the notification bell. We encourage you to get involved. So put up comments or questions. But if your questions are a bit more involved or a bit convoluted, I guess, best to use the link that will show up in the comments shortly. Just fill in your details and put it there. Today, Frank, we're going to revisit one of 2022's favourite topics, and that's hazards.
It is, and going a little bit wider than smoking. I think when we did this first time round, it had just sort of, I suppose, blew everyone's socks off in terms of the new interpretation put on the legislation on the part of an adjudicator, which is fine. And I think in that webinar, which we'll put up a link to, where we spoke specifically about it, I think we said we might do a little bit of a spitballing exercise in terms of what else could be hazards. And today, here we are.
So we're going to take some ideas about what could be a hazard in the strata sense and sort of see what we think. This is based, I think, Frank, on, I know plenty of people have sort of raised the topic with me. I'm sure they've done so with you as well. So we're sort of basing it upon that, but also a few ideas that we had as well. Let's just clarify that when we talk about hazard, of course, there has to be a legislative basis for it. Section 167 of the Body Corporate and Community Management Act. In fact, it talks about a whole bunch of things. It talks about nuisance as well. That's a bit separate. Today it's hazard. Frank, why was hazard a big deal recently? What's the drama here?
Just to revisit, and again, if you want all the gory detail, have a look at the webinar we'll put up the link to. Section 167 refers to people not being able to use their lot or the common property in a way that causes a nuisance or a hazard. So before this decision, all of our intentions when talking about people that were engaging in ways that weren't necessarily community minded, for want of a better phrase, was on the nuisance sections. So in our TEAC, there was the position where the typical smoking in strata, person below another person, and the adjudicator in this case, because all of the previous smoking fights, disputes had been around nuisance in terms of what was required to prove nuisance from a smoking perspective. In this case, the adjudicator said, in a sense, skip nuisance, it's a hazard. Smoke, secondhand smoke is a hazard. There's plenty of medical evidence that it's a hazard. And in terms of what's in the legislation, there's actually no statutory definition of what is a hazard. So I suppose as we get towards the end of the community title law reform working group, there might be some further consideration given to this, subject to what's floating around in the Commission's office. But in this particular case, the adjudicator said that hazard is a non-technical term that relates to situations for the potential to harm which has not yet occurred. So Macquarie Dictionary, again, always the old fallback for definitional stuff. It's a risk, it's an exposure to danger or harm, or it's the cause of risk or potential source of harm, injury or difficulty. So that, in relation to smoking, the adjudicator said is relatively self-explanatory because there's ample evidence that secondhand smoke is hazardous. So therefore, I'm going to make an order to prevent this sort of behaviour going on. And at the time, and for all of us, it's sort of what else is lurking around out there. And there's plenty of, I suppose there's plenty of stuff online about hazard, particularly in relation to workplaces, safe workplaces and all that sort of stuff.
We've popped that link up there now, Frank, about safe work. Yep.
Yeah. So, I mean, that's just another example of where governments have come up with, and that one is Safe Work Australia, talking about here's all of the different things that can be hazardous in a workplace. Now, you've got to remember, body corporate it's a 4 hours worth of webinars, isn't necessarily a workplace in terms of your own individual place of residence, but we're talking today about hazards and what else those might be. So that's really the sort of the scene setting for why this is relevant. And I think the other difficulty, not difficulty, the other issue with hazard at the moment is that we got that decision late December, it became public in January, to the extent that there are other issues working their way through the Commissioner's office at this point in time, having disputes about smoking or what else might be a hazard. So this is why I suppose, Chris, we're going on a limb today in terms of what we think those things could be. We're probably 12 months away from any further Commissioner's office judicial authority about how adjudicators are going to look at these things.
Absolutely, Frank. Well said. All right, well, let's move into a few we're going to sort of toss around a few ideas here about hazards, and we might sort of see if we agree, if we disagree. We invite people to sort of join in as well. Tell us about the eggshell skull theory, Frank.
This 1993 was when I first came across this, and I suppose you're a little law student, and one of the first things you study is torts, which is negligence and those sort of things. So, and I suppose as everyone might appreciate, when we come to common law, which is not statutory law, so our state government puts something in a piece of legislation, that's statutory law. Common law is law that we've inherited or over time interpreted pieces of legislation and so on and so forth. And one of the big things with hazards is it a subjective test or an objective test? So is it hazardous to the normal person, or is it hazardous to you, and you might have specific circumstances that make that particular behaviour hazardous? And I won't give away too much here by saying that some people might be more mentally fragile or scarred than others in relation to some types of behaviour. So I suppose between Chris and I, we've had plenty of spears thrown at us over the years. So maybe we've got a little bit of a thicker hide than some. Some people mightn't have. So the eggshell skull theory comes back to torts and negligence. You go way back when, and we'll put up a link for that. But, and this is in the context of if someone had a skull that was paper thin, so they don't have the normal protection that we have around our brains, and someone unaware of that condition threw a rock at them and caused them serious brain harm that wouldn't hurt you or I because of the way our skulls are formed, but did hurt them because their skull is formed differently, the defendant, the person that threw the stone, would still be liable regardless of those particular circumstances. So you know what I mean? You don't have to, knowing that your person or the person that you're hurting might be affected differently, or shouldn't be, or will be affected differently from most, is not a defence to that behaviour. That's the eggshell skull theory.
So, Frank, if you are an Oscar winner and you go up on stage and you smack somebody in the chin and they fall to the ground and die, it doesn't matter that you didn't know they had a glass jaw.
Correct. Correct. Or you told a joke about someone's wife that went down really badly and he's got a very special relationship with his wife that's more protective than most. The reverse, yes. So right, wrong, or indifferent. But yes, so that's the eggshell skull theory. One of the first things you learn in negligence. Way back when.
I like it. I think that's a really good point. Let's get into a few things, and that ties in nicely with the first one that we're going to talk about, which is mental health. So the hazard, I guess, posed to someone's mental health as a result of behaviour from an owner, an occupier, committee, caretaker, strata manager, and also the reverse of all of those as well. Where do we get to with that, Frank?
Well, I think this is probably more important than anything else. Like, you know, like this environment. I suppose, Chris, I gave a little interview with a journalist earlier this week. I suspect you're on the same list. I think you mentioned that. And talking about this sort of stuff in terms of the behaviour we see in Strata at times is the sort of behaviour that if you did it in a workplace, you'd be sacked on the spot and it would be completely justified. Now, that's not sexual harassment, that sort of stuff. That is name calling, abusive emails, intimidating behaviour, really not stalking type stuff, but the way people relate to each other in these environments can be appalling. And so particularly where mental health is justifiably being spoken about a lot more than it ever has been. That typical, I suppose, maybe Australian way to do it, particularly male side of things, is just suck it up, princess, and keep it all inside. Not anymore. So I think, and this is the context of that one, is that I think people's behaviour in schemes to other people can absolutely be hazardous, because hazard, it doesn't say physical harm, it says harm. Harm can be mental and physical. So I think that is well and truly something that can be played out over the next couple of years.
And I think, Frank, if you're going to follow that one through to its logical conclusion, you'd have to say, or maybe you don't have to say, but I would have thought that to sort of evidence the hazard, it would be maybe a report from your treating medical practitioner or psychologist that they have noticed a decrease in your condition over time, and it correlated with the first report of abusive emails or abusive conduct or negative interaction at the scheme. I would reckon the combination of those factors probably just about gets you there.
Yeah, because the evidence is always the big thing. So obviously emails are very hard to retract. I suppose the next one really then is sort of physical confrontations. You know, you come out of the lift and someone's standing their hands on hips, giving you a mouthful. Like that is next level intimidation. But it can have the exact same effect. So obviously the evidencing that without CCTV or a body camera or something on your phone or something like that is obviously going to be harder. But that absolutely can be hazardous. And I think there's probably a second part to that. And we see this a lot. And mate, I need to stop saying we've both seen this a lot, because we have, no matter what we're talking about, is the case. Standover tactics. You know what I mean? People that, and we both get it, people say things in Strata with an enormous degree of confidence, and quite often they're wrong. And sometimes knowingly wrong, just standing over people about the Commissioner's Office this, the Body Corporate Police this, section, whatever that, this is what I'm going to do. All of that sort of behaviour, I suppose that's a subset of what we're talking about, but that's sort of, almost, you know, standing over people in that context, I think is sort of, for me, stands out.
I think that's a really good point, Frank. The next one is the other kinds of smoke, and that goes towards Thurston. Thank you for your comment that you've made here. Thurston says, I thought the adjudicator should also have included barbecues on the balcony with its own smoke and fire risk hazard. So just to clarify, the adjudicator made the order that the smoker could not, I think, referred to the phrase tobacco product, which I then rapidly looked up, and that actually means vape and e-cigarettes. Yeah. So that is a hazard. But then there are the other kinds of smoke: incense, meat smoker, barbecue. You can chuck in marijuana there as well, but it remains a criminal issue, I would have thought, that one, but it can still be. Yeah.
And proving that they're hazardous. So when it comes to nicotine, cigarette smoke, cancer, well and truly proven.
Yep.
So I think, to me, smoking meat on your balcony, I think it's the evidence that can be hazardous, that can cause harm. So it might be annoying, which is then a nuisance, but can it actually cause harm? So the evidence on that, because in RT, the adjudicator, I mean, you've only got to Google it and away you go. Here's all the evidence. I don't need to go any further than that. So as always with these things, it's easy to make an allegation, but you've got to be able to back it up with something that proves it.
Absolutely. And the same goes for, I mean, I've heard the incense one a couple of times. So it's got to be about the particular hazard that's associated with someone lighting an incense stick on their balcony. Where can you find any objective proof that there's a risk out of that?
Mate, here we go. We've got combustible cladding on the building that has been allowed to stay there by virtue of going through the stage 3 process, and someone is using a smoking thing on their balcony that could set fire to the building. Is that a hazard? That's how
probably is.
In Melbourne happened. Yeah. Maybe.
I think there's also a medical condition about resulting in hypersensitivity to smells. So that too could be hazardous.
So skull theory in practice.
That's right. So Thurston, you're right, but I think it comes back to the evidence. You've got to be able to show where the risk comes from there.
Building works.
Yeah, monopolizing the common property. So I'm guessing, Frank, this might be a situation where I know. So what about a circumstance in which there's only two lifts for the building, for argument's sake, a high rise, and one of the lifts is closed, one of the lifts is not operational because it's broken. The other one, somebody's moving in or somebody's moving out, and they go through that whole process of reserving. It usually happens in buildings, doesn't it? You reserve a time. That's a hazard, isn't it? Doing that.
Everyone else has got to use the stairs and they're all overweight and unfit or old. I should rephrase that. I shouldn't be so judgmental. Yeah, potentially. I think that's a longer bow to draw.
Yeah.
And I suppose from a body corporate perspective, what's reasonable in those circumstances, you come back to, you know what, really sorry, but between 7 and 10 and 4 and 6, everyone is coming home. So if you, and lunchtime, they're in and out. So you have a 2-hour window here, you can do it at night, whatever it might be a way to manage that one.
Yeah. So next up, we're going to talk about pets, and there's a few different aspects when it comes to pets. So particularly pets not behaving properly. So urine, barking, those are already established as nuisances, but there needed to be some, well, not so much established as nuisances, but there have been orders made about that. In terms of hazard then, I suppose, Frank, I think more or less the same, isn't it? It's the same kind of logic here.
Yeah, and I suppose part of it for me would be at what extent are you exposed to hazard by virtue of this behaviour you're not exposed to out on the street? You know what I mean? I think it's probably, because again, I think sometimes it's very easy to get caught up in these laws give us these rights, but they're not really over and above, sometimes for me, what your rights might be with respect to your neighbour anyway. So I think, hoarding, the crazy cat lady with 15 cats and smells and vermin and viruses potentially and stuff like that, maybe. But I'd say probably most of those are probably leaning more towards nuisance. But again, subject to, like all of these things depend on the facts and circumstances, don't they?
Absolutely. But then that leads us to type of animal, type of pet and breed of pet. And I had this question posed to me by Strata Manager today. It's a very tense situation involving two owners, but one of the owners is talking about getting a German Shepherd and training said German Shepherd to be a security dog. Interesting. And my response was, well, we go through the whole pet approval process, blah, blah, blah. It's not about the breed, it's about the animal. And then they mentioned something about dangerous dog or banned dog. So we've got a link there to a Queensland government website about what are called regulated dogs. So there is such a thing as a regulated dog and such a thing as a restricted dog. There are certain dog types which are just completely banned from coming into the country. I think that's a customs decision. I'm not 100% sure. And then there are regulated dogs. So you can only have the animal under certain conditions. From the local council.
One of those dangerous dog signs, for example, you see on front gates, yeah?
Yep, that's exactly it, Frank. But back to our German Shepherd example. So my response to the manager was, well, yeah, German Shepherds can be confronting when taken in a particular circumstance, but equally, I thought German Shepherds could be very docile and very playful. I think you'd be needing to show some evidence from RSPCA or the Vet Association or somewhere else that that particular breed is especially known to be violent in a particular situation. Frank?
Agree. And I think that's more behaviour of that particular animal after it's happened, unfortunately, than shoot first and ask questions later. So refusal on the basis that it could do this is usually to say no.
You go to the RSPCA website and it makes a very clear statement that every dog has the potential to be violent. Every dog. Even the greyhound, which has been asleep for the last 10 hours, has that potential if you happen to look like a cat. Let's keep going. We've got a few questions coming in there. We will get to those shortly. A actually, this one goes to the comment from Janae, who says, we have a tenant who spits over the balcony onto the common property. Well, apart from that being incredibly gross, is that a hazard? I would have thought there's a significant risk associated with that. And the most obvious one is what happens if you slip on that? That creates a slip on it, doesn't it?
Possibly. More so than rain.
That's a good point, Frank.
I don't know.
Okay.
Like, to me, that's definitely a nuisance. That's almost certainly going to be a breach of the bylaws. It's just rude. But whether that's a hazard or not, I think is something else entirely. But I think when you come to balconies, like I reckon, particularly in windy areas, stuff being left unsecured can become a hazard. I mean, we've had some really interesting La Nina weather recently. The other night, there's wind that I thought was going to blow the house over. Like, if you've got lighter material on your balcony and it goes sailing around, which is distinctly possible, that's hazardous.
Absolutely.
So
And
requiring people to secure things might be reasonable.
the old bottles and cigarette butts, I think that's pretty obviously. There was that terrible story, I think it was in Singapore, just like last year or the year before, where an Australian expat threw a beer bottle off a balcony in Singapore and hit the caretaker and they died. So I think that's pretty obvious where the hazard lies in that case. Yep. One that gets asked sort of fair bit, Frank, is noise as a hazard. And one example that we've got is like moving furniture. It's irritating. Is it a hazard?
That's back to that eggshell skull. You know, it's like if you're sleep deprived, I don't know. It's sort of almost you go back to Jaws and Quint when he runs his fingers down the blackboard. Like, that makes me cringe. Having it happen all day, every day, absolutely. But it'd have to be, I think, for that sort of behaviour to be a hazard as opposed to a nuisance, would take a lot of it to happen. And I think evidencing that would be really hard.
I think so too, actually. It's not, and again, we're not diminishing the problem. No. Not at all. But hard one, I think, to actually put some evidence around that. We'll quickly go through a couple more because we're sort of getting towards the end. Interference with the operation of common property, and we've got an adjudicators order that we'll put up there for you in a minute. So in this particular order, the owner in question was interfering with lifts. We'll let you read that one at your leisure. It was all pretty out there stuff. That's clearly a hazard, Frank, I would have thought.
It is, and it's a really interesting thing where, you know, normally, I suppose, the Commissioner's Office can be criticised for being slow in terms of bylaw enforcement. And it's not them being slow, it's just that the mechanics of the process can be unwieldy when something needs to happen urgently. But there is a single provision there. For those of you that are keen, go have a look at section 186 of the Act. That allows an adjudicator to dispense with the normal bylaw enforcement process if, Chris, and I just might mention this, there's special circumstances, special circumstances are for things that are likely to cause injury or serious damage or a risk to health and safety of persons or causing serious nuisance to persons. So there is the ability to go and effectively get an interim order to stop behaviour, avoiding the need to go through the bylaw process, but, and hand on heart, I've never seen that provision used. So it's.
I've seen it. I've seen it once, Frank. Yeah, I've seen it once, and that was only because a client sort of brought it up with me just this week. I had to go looking for it, and yes, I did find one. It was about silica runoff, and the adjudicator agreed that posed a special circumstance which warranted dispensation. I want to get. We've only got a couple of minutes left. I want to get to some of these questions because they're good ones. Frank, I want to go to your asbestos door story.
Had a client who was a body corporate who was replacing doors in an older building, but not at the pace at which some owners wanted it done. So a couple of owners took it upon themselves to go and pull the door down, put in a new door, and that involved screwdrivers, unlocking, deadbolts, all sorts of things, and the doors were asbestos. No, and there was no vacuuming, no notice, no nothing to anyone. So to me, no brainer. Would have been a hazard. I can't actually remember how that finished. It's years ago, but I still find it quite extraordinary that when it was put to them, you shouldn't be doing that. It'll be right, mate.
Clearly, it wasn't. Let's just go to some of these questions because, as I say, they're posing some good ones from Sam. Thanks, Sam. Would you consider short-term rentals within a Class 2 building a hazard? Some older residents shut themselves in during holiday season because they are worried about the unknown holiday makers. So let's go back a step, Sam. If we go back to the start, we talked about hazard in terms of risk, the risk of something happening. So is there an inherent risk in a short-term holiday maker? Don't think so.
Leap of faith. Yeah, and in a sense, how is it any different to someone being invited into someone else's home as a guest? That would be my take. And I think the whole Class 2, Class 3 thing gets blown up about short and long term. It well and truly been litigated at the Watergate building down in Victoria that the classification of a building means nothing with respect to the potential of the occupants of the units. So yeah, don't get caught up in that one. But as much as there's some substantial proponents of a view to the contrary out there, but I think that'd be hard pressed to be a hazard.
I think so too, actually. Philip, thanks for your comment. OC owner eye gouging balcony clothesline permitted in return for a vote. Interesting. So what I'm gathering you're suggesting, Philip, is that approval was given for the owner to install a clothesline which had some potential to poke someone's eye out. That to me, I don't know what you think, Frank, but that to me suggests that the clothesline is extending into common property airspace.
Yes, otherwise it's their own property. And probably, Philip, I'd be a little bit scared with the word OC, which connotes somewhere other than Queensland, because we're talking specifically about Queensland. I'm not sure what other jurisdictions have in relation to these rules, but possibly, installation of a clothesline in a way that's not safe could be a hazard, 100%.
Well, I would tend to think, Philip, the issue is probably if it's extending into common property, it needs to be dealt with that way. David, thanks for your question. Would use of herbicides like glyphosate as a probable carcinogen for human a hazard? So I'm assuming, David, you've got that information from somewhere. And probably this is a good point to point out, Frank, I don't think it's good enough to go to Wikipedia and get evidence of a hazard. You probably need something just a little bit more authoritative and objective. So that, not that that's what I'm suggesting, David, but say, for example, the World Health Organization listed that particular herbicide as possible carcinogen causing in a human. I think that's a no-brainer being a hazard, Frank.
Yep, because it is a hazard.
Yeah.
So I suppose any form of chemical is potentially hazardous, but then it's a matter of, and I suppose, and this is one of the things that the adjudicator didn't deal with Artique, is where's the line? Yeah. So if I sit there and ingest a breath of secondhand smoke as opposed to 3 years of it, there's obviously, it's still risk, but it's a very unlikely prospect of harm coming to me from having one breath as opposed to 3 years of it. So we haven't had that conversation yet.
We have not. We need to wrap it up just very quickly. What does all this mean? I think for a committee in particular, if anything is brought to their attention, which is hazardous or potentially hazardous, then they need to be, you can't let it sit, I think is the message that we're sending, because now we have some quasi-judicial consideration of it. And there was a particular message for committees in that Artique decision, wasn't there, Frank?
It was just don't ignore this, get involved.
Yep, absolutely. We need to wrap it up at that point. Again, if you're new to the show, we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. So to follow us on Facebook, go to the Hines Legal page and hit the button and icon. For YouTube, hit the subscribe button and the notification bell. We're there. Thanks, everybody. A lot of good questions there today. Stuff I hadn't even thought of, to tell you the truth. So that's really good. Yeah. Thanks all. Frank, thank you.
No worries, mate. See you next week.